Hi, this is attorney Nicole Christie from the Christie Law Firm, where we are here for our families. And so we wanted to talk to you about the plea and disposition date. Now, there are two types of pleas and disposition dates. There's one where the kids are at home, and there's another when the kids aren't at home. In this video, we will talk about when the kids are home. So the judge has to make a decision about the allegations that are made by DCF. You usually find those allegations in the social work affidavit. They're very specific to the case itself. And then they have to make a determination about what to do with those allegations. So it has two different parts. The adjudication, again, about the allegation, and then the disposition. If you have decided to not go to trial, and again, trial is always your right, but if you've decided based on the facts and based on whether or not DCF can prove their case, or whatever is the reason for not going to trial, which again is still a right even to not go to trial, then the court schedules what they call as a plea and disposition. And so at the plea, the court will want to know, does the parent admit to the allegations? Most do not, because half the time, some of those allegations are not correct or accurate. Some of them are true. Rather than going back and forth with that, most opt for what they call a nolo. And a nolo contendere plea, really the whole Latin term for it, means that you don't contest the allegations, but you don't agree to them. So for example, DCF could list 10 different things. They could talk about substance abuse, they could talk about mental health issues, they could talk about several different things. All the court has to find is that one of them is actually true. So if they list 10 different things and you disagree with maybe 5 of them, all the court has to find is that one of them is true. And rather than go through this back and forth about which one's true or which one isn't true and take the time for a trial, a parent can enter what they call a nolo. So what you basically say to the court under this nolo, and it's a specific form that we as your attorneys would have you sign, that you, one, do not wish to contest the allegations, but you're not admitting as well, that you're giving up your right to a trial, you're giving up your right to cross-examination, and you want to take advantage of this agreement and enter this nolo form. And so there's more details for the form, and we can go over that in detail with you. But in essence, that's what the form is saying. You don't want to go to trial. You're giving up your right to a trial. You know you have an attorney, but you just want to take advantage of this agreement without having to admit or deny. And once you do that, the court will also want to see that in writing, so we would have you sign that, but they'll also ask you a series of questions. And those questions are designed to make sure that the plea itself is actually voluntary, that no one forced you to do this, no one told you you had to do this, no one made you do it. You'd be surprised, but the court wants to make sure that this is free and voluntary will, and it's not something that anyone encouraged you to do in a way that's against your will. So they'll ask you a series of questions. Don't be shocked by them, so I'm going to go over the majority of the questions right now. So they'll ask you, did you have anything to eat or drink that is going to impact your ability to understand, or have any medications that would impact your ability, or used any substances that would impact your ability to understand what's going on? People do show up to court sometimes under the influence, so they want to make sure. They will also ask, have you had enough time to talk to your attorney? Are you satisfied with your attorney's advice? And if you're not, you need to say so. But as one of our clients, we'd make sure that we had enough time to talk with you and that you understood everything that was going on and made a decision with us together. So hopefully you'd be satisfied with your attorney's advice. They will also ask, have you gone over the allegations with your attorney? So we go over what DCF has to prove and the burden of proof. They will ask you whether or not you understood those allegations. And they will also ask you whether or not you're doing this free and voluntary, free will, and it's voluntary. And this is what you think you should be doing at that time. And so they will want to make sure, and they may even ask the attorney. In some courts, they'll say, attorney, did you actually go over these things with your client? And so once they have done this thorough investigation meaning series of questions into whether or not you have actually done this voluntarily, then they will accept your plea. And again, if the kids are home, the next set of court dates are going to be important to hear, and they're going to be different than any other proceeding. The next set of court dates you will hear are, number one, the end date of the protective supervision. Generally, it's for 6 months to begin with. Sometimes it can be longer, sometimes it can be shorter, but generally it's 6 months. So you should be hearing the end date of the protective supervision. And you'll also hear about an in-court review. I love those, because that is where, if everything is going really well, you can ask the court to end the protective supervision early. So we, as your attorneys, would file to end the protective supervision early. So those are only 2 court dates that you will hear. So once you get to that plea and disposition date, then there's 2 more court dates, or actually 1 more court date, and then the end of the protective supervision. So after that in-court review, that should come up normally between the 4th and 5th month. Sometimes they'll ask for it at the 3-month mark. But nevertheless, once that court date is heard, there are no more court dates. You are in the home stretch. And so either the court will decide to let the protective supervision just end on its own, or they could end it early. Now, the only exception to that is if DCF says, hey, there was some issues, we didn't get a service started, there was a problem getting compliance earlier on, and we want the protective supervision to be extended. We don't like to hear that, so we encourage our clients to comply, do the things they need to do necessary to end, but sometimes the court can extend it. I've seen it extend a long period of time under, very difficult cases, but sometimes it's really just to see a client finish out a service. So I encourage you, from even before you get to plea and disposition, if there is a recommended service, we know the judge is going to order it, start it right away, so that by the time you get to that in-court review, there's nothing left to do but to end the case. So this is the process of the plea and disposition for when the kids are home. In another video, we'll talk about the plea and disposition for when the kids aren't home, and what are some key dates to keep in mind. Take care until next time.